he will not have enough money to buy food.
Forget about rent, mortgage, food, utilities. What am I supposed to pay?
We're set for 2 matters in this case today. Number one, the first thing I'd like to address is plaintiff's motion regarding alleged failure of defendant to comply with the court's ruling. And then we have Mr. Cutler, defendant's objection to the proposed judgment of divorce drafted by Mr. Vernon. So Mr. Vernon, addressing your client's issue first, my understanding based on the written submissions is that your client's motion is based on the failure of Mr. Serra to make payments.
Yes, I did not participate in the drafting of that document. Mr. Serra did that of her own accord. My understanding is that Mr. Serra has failed to make payments on the vehicle. The March payment has not been made. The April payment is due. That has not yet been made. And the car
support, the insurance.
Oh, and then and then there's the support that hasn't been paid.
And the pension.
Right. When I say the support, I mean I suppose I mean the pension as well. But so none of those payments have been made. And court order states fairly clearly that Mr. Serra was intended to make those whether this order was entered or not, or at least until it was entered. And because counsel objected, we have not yet had an order entered until probably today. Mr. Serra would be responsible for making those payments.
All right, thank you, Mr. Cutler.
Thank you, Your Honor. As far as the pension, that topic first, the pension is not paid for my gentleman. It is through the pension agency. The pension payment was requested and it was submitted. Our understanding confirmation from Mr. Serra is that the 1/2 portion of the pension was paid on March 29th. They do it automatically every month. As far as the payment of the $1,000, we did not have any address for Ms. Serra. I contacted opposing counsel. Eventually, I got a response from him. Within 4 days of getting that response, my client submitted a cashier's payment in the amount of $1,000 to the P.O. box that was provided to us. As far as the car and the insurance, the order of the court, the opinion of the order of the court was that both parties were to engage in certain activities relating to the vehicle. Ms. Serra was to transfer the title and transfer the obligation to her name. Apparently, she has not undertaken any steps in that regard.
Okay. All right. So the court is going to order that the pension payments. Well, first of all, can we, Mr. Vernon, can we put on the record here today an address for Ms. Serra that the payments should be sent to?
It's P.O. Box 147, Grayling, Michigan 49738.
I'm sorry, can we have that lower? I was writing it down, Your Honor.
P.O. Box 147, Grayling, Michigan 49738.
Thank you.
Okay, so the court's going to order that the March and April payments as provided in the court's opinion in order be made within the next 14 days and sent to that address. With regard to the vehicle, those obligations, in my view, would not arise, unlike the payment of the pension and support, which the court expressly provided for in the opinion and order. The other provisions, such as the vehicle, would be effective at the time that the judgment of divorce is entered. So I don't find that Ms. Serra's obligation has arisen until that judgment has been entered, which I suspect we're going to be able to resolve here as the next matter today. So I am going to order that Mr. Serra make the March payment as to that vehicle, as he has been making all along. And then that, assuming we address the issue with the judgment of divorce, then once that's entered, then that obligation will transfer to Ms. Serra, along with the obligation to refinance that vehicle and remove Mr. Sarah's name from it. So that's how we'll handle those two issues. With regard to moving on to the next subject of the motion, which is Mr. Cutler, your motion regarding the judgment of divorce, I did review your filing. Is there anything that you wanted to state in that regard today?
No, Your Honor, I think I highlighted, I requested drafts of the judgment, so we didn't have to have this delay. Unfortunately, I never received the draft. I never received what I had hoped to be cooperation to review the language to address these. I think I have three requested, actually two changes, one omission, and then two grammatical errors, which include provision that I don't think the court ordered. So it's really 5 issues in total. Unfortunately, we're delayed to today's date, but I do want to have those addressed. And I think I expressed them to the court unless the court had any specific question of me.
I don't. Thank you. Mr. Vernon?
So I'll take them one at a time. With regards to the language that Mr. Cutler proposed for the vehicle that states that plaintiff will be required to remove the defendant's name from the title and that, I think that's consistent with the court's instructions, so I have no objection to that language. The student loan, we did refer to it as the Parents Plus, and the court did refer to it as student loans. I have no objection to that. There is a request in the in Mr. Cutler's answer to the show cause, suggesting that my client is responsible for 1/2 of the monthly payments. I would disagree with that, and that the language in the order that the court drafted simply said that the debt is divided equally, not the monthly payment structure is divided equally. So I think that is an inappropriate language. So the proposed language that is in there with regard to the student loan, that states that the student loan debt, including any Parents Plus loans made by the parties during their marriage, is to be divided equally between the parties. I don't have any objection to that language. With regards to the attorney's fees, again, that's fine. I don't have any problem with that language being added. I think the typos that he pointed out are accurate, should be corrected. The only other thing I would add is that the Michigan Court Rule 2.602 subsection B3C identifies that the party filing the objection, that would be Mr. Cutler, must serve on the parties all of the objections together with a notice of hearing in an alternative proposed judgment or order. Mr. Cutler did not do that. He included the proposed language in his motion, but we do not have a proposed alternate order. So the suggestion that I have to make those changes to the order, I believe, is inconsistently placed, consistent with the court rule, and that is something that Mr. Cutler would have to draft and submit.
May I address that, Your Honor?
Yes.
Thank you. Once again, if counsel responded to my request and I sent 3 or 4 requests for the draft, then I could have obviously included some of these changes. For whatever reason, I received no cooperation, and I've adhered to the court's opinion stating that objections would need to be filed as opposed to an objection with a separate motion was pursuant to the court's order. Counsel has the language. The changes are minor, so I'd ask that he make those changes in light of the history of our relationship up to this point. I would like to make one inquiry of the court. The court specifically stated that the student loan debts, these Parent Plus debts and obligations, are marital obligations. They are to essentially be equally shared between the parties. If Ms. Sarah is not going to be submitting any of the payments, if she's going to refuse to submit her half portion of it, my client does not earn sufficient funds. The court has the numbers clearly. My client cannot make that payment. I would ask alternatively that if Ms. Sarah does not make the required payment on this obligation, And the amount is, I believe, I know Mr. Sarah gave me paperwork on it. I think it was $1,400. If he has to make the $700 payment for his portion and the $700 for Ms. Sarah's portion, he will not have enough money to buy food. So as an alternative to this, I would ask that if she's not going to submit the payment, that Mr. Sarah be given the option to submit the $700 from the spouse support obligation on her behalf. He can submit the payment to those loan agencies in a timely manner, and they won't be in default. Otherwise, we're going to be right back here before the court. So I'm trying to get ahead of a problem that, based on what counsel just stated, I foresee.
Okay. All right. First of all, with regard to defendant's objections, based on Mr. Vernon's statements, and I agree with Mr. Vernon and Mr. Cutler, looking at, first of all, paragraph number 1 regarding the vehicle, I think we all agree that, Mr. Cutler, your language is appropriate as cited under paragraph number 1 of your objection. With regard to the student loans, again, the court would adopt the language that you have proposed under paragraph number 2 of your objection. With regard to the attorney fees, again, the court would adopt the language proposed by Mr. Cutler under paragraph 3. And the typographical errors addressed by Mr. Cutler under paragraph 4. Neither of you referenced the cash surrender issue under the statutory insurance provision of the proposed judgment. Mr. Cutler, you raised that as an issue under paragraph 4 as well. I'm not sure what significance the difference is. To me, reading Mr. Vernon's paragraph, it looks like each side gets their insurance at any value that it might have. So is there a reason why you didn't want that language in there, or you didn't think it was appropriate?
I didn't believe that the court referenced in its ruling any portion to a cash surrender value. I believe it merely stated that each party essentially retains it. When we start getting into cash surrender values, then I start to be concerned as to what are the values and if they're offsetting. I'm just trying to reflect within the final judgment the language of the court.
All right, and I didn't address that. The parties never raised that as an issue for decision by the court or dispute between the two of them. I don't view that as to be an issue that has particular significance here. So I'm not going to require Mr. Vernon to change the language of the statutory insurance provision in his proposed judgment. I do agree with Mr. Cutler that really, from the standpoint of the resources of both parties, these changes will take minimal time and certainly much less time for Mr. Vernon to simply make corrections to the judgment that's already been drafted, as opposed to the time and expense that costs for the defendant to draft up an entirely new judgment. So the court will order Mr. Vernon that you make those changes to the proposed judgment and submit that to the court for signing. In terms of Mr. Cutler, your issue regarding the student loan debt, I appreciate your efforts in trying to get ahead of that issue. Generally, courts are loath to decide any issues that aren't directly before them. Your motion involved objections to the proposed judgment. The court did not, as Mr. Vernon indicated, order as part of the opinion in an order that Ms. Sarah make payments. And I can foresee that may be an issue that comes forward, but I view your motion much more, your request, Mr. Cutler, as a motion to enforce a judgment of divorce, the provisions of that hasn't been entered yet. So I think while I do appreciate your forethought in addressing an issue that may and perhaps even likely will arise, at this point, I think it's premature. So the court is not making any rulings with regard to that request at this time.
Understood.
So that is the ruling of the court as to both motions. That's all I have on this file today, and all parties are free to disconnect at this time.
Your Honor, if I could just ask, when is Mr. Vernon to submit that change? Can we have a time period, whatever number of days, please?
I would suspect, Mr. Vernon, can you have that within the next 7 to 14 days to the court?
Yes,
Okay.
Thank you.
Your Honor.
Your Honor, my, Mrs. Sarah, has a couple of questions related to the show cause order that she filed, or request that she had filed, so I'm gonna request the court allow her to ask a couple of follow-up questions.
Your Honor, I'm
Okay.
to that if we could. Arguments that have been made, the court's already made a ruling.
It's just for clarification.
Yeah, I'm not changing it. Mr. Cutler, I assure you, I'm not changing anything about, but Ms. Sarah has questions. I'm certainly going to allow her to ask them. So go ahead.
So the March and April car payment, as well as the insurance, will be paid by the defendant, correct?
March.
March. Okay,
Yep.
April due in like 3 days. Am I gonna have payment to pay it?
Yes.
Okay, the pension, I have not received anything. I should have received 2 months already. He gets paid on the first of every month.
Yeah.
And you
Yep.
have
I've ordered that he make both months' payments within the next 14 days to the address that you provided.
Okay, Your Honor, is there any way that the payments can be made through the court so I don't have to deal with this for the rest of my life?
That's something that you can address through Mr. Vernon, but that's not something I can address here today.
And Your Honor, it appears that my client has some response. If likewise, he can be given that opportunity for clarification.
Yeah, if you have questions, Mr. Sarah, that's fine. I'm not going to get into a debate about when you get paid and when you don't get paid. So if you have questions, you can ask a question.
I can't hear you, sir. You're on mute.
I'm sorry, I do, Your Honor. I received a half payment on my pension as of, I received my pension towards the end of the month. And last month it was the 28th or 29th, and I did receive a half pension payment of roughly $925. I myself applied for the Quadra and made many phone calls to make sure the Quadra was in place. So as far as I'm concerned, the Quadra is in place. I do not know why I would get half a pension payment and Mrs. Sarah does not. Ms. Sarah, the plaintiff, did not. The other thing I might request is I roughly make $4,000 a month. Paying the plaintiff half of that leaves me $2,000 with a $1,400 over a $1,400 student loan payment, a $660 tax payment, which is marital taxes from 2021. That there is my entire income. I have no more money for another car payment or an insurance payment. I need direction on, out of my $2,000, which forget about rent, mortgage, food, utilities, what am I supposed to pay when I only get $2,000 a month? I'd like some direction on what I'm supposed to pay, please.
Mr. Sarah, my job as a judge in this case is to equally divide up marital assets and debts. I've done my best to do that. I didn't live your life for you. I didn't accumulate the debts that you've accumulated. I didn't put you in the position that you're in. So in terms of, I don't have any advice for you about how to live your life and do what you need to do. All I can do is do what I'm required to do, which is to divide up assets and debts as equally as I possibly can. And I've done that. To the extent you disagree with the way I've done that, your remedy is to appeal it. And I encourage you to do that to the extent that you want to get things changed. Otherwise, again, it's not my job to figure out how you're going to live your life. You need to figure that out on your own.
But I'm in an impossible position.
And I guess you put yourself in that impossible position by doing things the way that you've done. And that's not my fault.
Not maritally?
So I'm
All
not
right.
going to debate you. That's all I
Okay.
have to say. All
Thank
parties
you.
are free to disconnect at this time.
Thank you.
Thank you, Your Honor.
That also